So you've been served with a lawsuit. What do you do? Other than that, if you were sued by an aggressive lawyer for 5 years and a sue-happy plaintiff, and you did not have an asset protection plan in place, and you lost all of your assets, including your home, would you have any regrets for not having an asset protection plan? Would you have a hard time with that? If your answer is yes, we're going to talk about what you can do to protect your assets after someone has already served you with a lawsuit. And when you watch this short video to the end, you'll know exactly what doesn't work and what does work. You'll know exactly what to do so you can sleep like a baby, knowing your hard-earned assets are safe and secure to take care of you and your family. Hi, I'm the Business Guy, and today we're going to talk about the #1 way, the best way to protect yourself from lawsuits after you are sued. And if you could do me a favor and please click the like button below, it would help me a lot for the YouTube algorithm. Thank you so much. And in the comments, tell me what you think. And you can also click the subscribe button so that when more videos come out like this, you'll get notified. Okay, so there's a lot of talk on the internet about asset protection, but who can you trust? Now, as of 2021, I've been in the asset protection business for 30 years. That's since 1991. We have lawyers on staff you can call right now, and you can talk to them about your specific needs. You'll see our website and phone number below, so you can fill out a free consultation form right now if you want to. Now let's talk specifics. First of all, what about an LLC or limited partnership? We have videos about LLCs, single-member LLCs, multi-member LLCs, and how they can help protect your assets in some cases. The problem is you've already been sued, or maybe you're about to be sued. So putting your assets into a domestic limited liability company creates lots of problems. First of all, the courts would grant your opponent a fraudulent transfer ruling. Please see our video on fraudulent transfer / fraudulent conveyance. Same thing. This is when somebody transfers his or her own non-exempt assets, such as cash, stock, or real estate, with the intent to delay or hinder collection by a creditor. The important thing to know is this is a civil remedy only. It is not a crime. In most states, you generally cannot go to jail for it. In a handful of states, they have added fraudulent conveyance to the criminal code, but it typically deals with very specific intent, and we know of no one of our clients who has ever crossed the line into anything but civil rulings. Nothing criminal for protecting assets. And as the largest asset protection company in the nation, that says a lot. So what is the takeaway from this? It's that you can't put your assets into an LLC or transfer them to mama and rely on that protecting you. You'll get absolutely creamed in the courtroom, and they will sue the family member who you transferred your assets to. That would likely not be a happy time at Thanksgiving dinner. So don't pull your loved ones into your own mess. Moreover, you'll lose your assets. So don't think you can randomly transfer your assets to another person or to a U.S. company. In our vast experience studying actual case law in real courtrooms, it's not going to work. Now, what about domestic trusts? There are trusts in Nevada, Wyoming, Delaware, Alaska, and other states that have asset protection trust laws. What if you live in California, Texas, New York, Florida, and you put your assets into a Nevada trust? You talk to promoters of these trusts, and they'll tell you anything you want to hear. But if you peel back the onion and look at the case law, these domestic trusts aren't all they're cracked up to be. First of all, if you live outside of the state, we see judges consistently apply the laws to both where the person is and where the assets are. Now, U.S. judges, as you know, have jurisdiction over U.S. assets. That is U.S. real estate and bank accounts. And results-oriented judges will find a way around anything they can get their hands on. You can be the most honest guy or gal in the world, but in the courtroom, your legal enemy is bent on making you look like the devil incarnate, dripping venom off of your wicked fangs. And this is what the opposing attorney is paid to do. And the judge doesn't know you from Adam. And since the judge sees the plaintiff's arguments first, the judge's first impression is that you're an evil monster. So there's no heart there. And as you know, the opposing attorney may get a slice of whatever they get from you. So there's no feeling sorry for you. The attorney on the other side feels just as sorry for you as the pride of lions has for the baby gazelle when they're going for the kill. Hey, you're just their next meal. And in order for that contingent fee lawyer to feed his own family, he has to get paid from taking money from you, the money that you worked hard to earn. So there's no sympathy there. Now, I can't even count the number of clients who have told us they were in a frivolous lawsuit and it was just a nuisance lawsuit and they were going to win. Their attorneys convinced them it was a slam dunk. But like U.S. Army General Norman Schwarzkopf says, listen, it's choreographed. And what happens is the orchestra starts playing and some son of a gun climbs out of the orchestra pit with a bayonet and starts chasing you around the stage. And then the choreography goes right out the window. In other words, you can have all the great expectations you want, but when the bullets start flying for your head in the courtroom, the whole game changes. Now let's get specific. What does work? What will protect your assets from lawsuits? Many asset protection experts agree that one of the strongest asset protection tools in the world is the international trust in the Caribbean island of Nevis or in the Cook Islands. Now, Nevis is located southeast of Florida, and Cook Islands is located due south of Hawaii. They have the strongest asset protection case law history in the world. Now, it's not just theory, but each time we have seen it tested, it has protected our clients' assets. Now, here's the important part. The reason the international trust works, where the domestic ones don't, is that the local court says, give me the money. The trustee, which is our Cook Islands or Nevis law firm, outside of the local court's jurisdiction, will not comply, as your local courts don't have jurisdiction in Nevis or the Cook Islands. Now, here's some of the benefits. In Nevis, for example, a creditor must post a $100,000 US bond with the Nevis government before bringing legal action against an international trust. And unlike most countries, Nevis or Cook Islands trusts can last indefinitely. Neither place recognizes foreign judgments. In fact, only a handful of countries offer this benefit. The ordinance in Nevis allows you to combine two trusts into one or split one into two. If a creditor brings a fraudulent transfer action, they must do so within a year of the cause of action or the reason why the lawsuit was filed in the first place, such as a car wreck. 1 to 2 years in the Cook Islands. That is, the courts won't even hear the case. So it's in your benefit to set up the trust as quickly as possible to get the clock ticking. Number 6, in the unlikely event a creditor files quickly in Nevis, they will have to post the $100,000 US bond and prove their case beyond a reasonable doubt with clear and convincing evidence in both Nevis and the Cook Islands that the settler established the trust to keep the money from that particular creditor. Not any creditor, but that particular one. This means that if the settler set up the trust for any other reason, such as international diversification, estate planning, etc., it would be very difficult for a creditor to prevail. Moreover, the creditor risks forfeiting the $100,000 US bond in Nevis. And number 7 is to hit that like button and subscribe to this channel. Now, trust law uses the step into the debtor's shoes theory. Whatever the debtor could do directly, the creditor can step into his shoes and do that same thing. So that is why it is so important that an experienced professional drafts the trust and that you have a licensed trustee such as our law firm there. Our on-staff attorneys draft the trust professionally according to your needs. Now, what about your control? Now, when we set up a trust, we want to give our clients the remote control. So a trust owns 100% of a Nevis LLC, and we make you the initial manager. So the client is the manager of the LLC, which controls the LLC assets and is initially the signature on all bank accounts. Now keep in mind, your account need not be in Nevis or the Cook Islands, but it can be in any financial institution in the world that offers a financial safe haven. Now, when the bad thing happens, you can temporarily have our law firm step in as manager of the LLC. Now, our international trustee law firm is licensed and bonded. Plus, they went through intensive background checks to get a trustee license. And by bonded, we mean the funds are insured. So for client safety and peace of mind, the only time our law firm steps in is when the courts would take the money. So the question that is asked is, would you rather have a 100% chance of the courts taking your money? Or would you rather have our licensed, bonded law firm, who has never taken a client's money, do what you've paid them to do, and that's protect your money? Now, when the bad thing goes away, the string of control, which is the management of the LLC inside of the trust, goes back to you, and you're back in the driver's seat with all of your money intact. In the meantime, during legal duress, if you have bills, the trustee can pay them for you. You can have the trustee pay a trusted friend or relative who provides money for you, etc. So you still have access to the money, but your enemy at law does not. The bottom line is everything you've worked so hard for is safe and secure. Now, the best asset protection the trust provides is for liquid assets held offshore. The courts do have jurisdiction over U.S. bank accounts and real estate. So for real estate, we do what is called equity stripping. We record mortgages against the property, initially payable to the LLC. Then, if needed, we have a third party purchase those mortgages and place the proceeds into an inaccessible account in your offshore trust. Now, we set up a lot of these trusts for other law firms. In fact, we've set up more offshore trusts than anybody we know. Then the attorneys charge between $30,000 to $50,000. Contact us directly, and we can set up a trust for you for a fraction of that price. So if you have questions, you can give us a call at 1-800-830-1055 or visit us at assetprotectionplanners.com or on our international website at offshorecompany.com. Thank you.